Okay, I think welcome everyone then to our event, The Right to a Clean, Healthy and Sustainable Environment, Old Hat or New Hope, as we coined it a bit provocatively maybe. This is a joint event by the Institute for International Law of Peace and Armed Conflict and the Law Faculty in Bochum and the Interest Group on International Human Rights Law of the European Society of International Law. Welcome to all of you. I am sure more and more people will come in. We had quite a high number of registrations, so I hope some more people will join. And of course, a very special welcome to the 4 guests that we have here today. And I'll introduce all of them just before they will take the floor. My name is Tilburg. I'm Professor of International Law at Ruhr University Bochum and your host today. So let me briefly set the stage before we give our first speaker the floor. Why is the right to a healthy environment, if I may abbreviate, why is that potentially an old hat? So if we go back to 1972, exactly 50 years ago, half a decade ago, we find the Stockholm Declaration on the Environment, which I'm sure most of you know. We had this year great celebrations of Stockholm plus 50 in June in Stockholm. And we had this great declaration, and in that Stockholm Declaration of 1972, we have Principle 1, which already in 1972 stated, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being. So we see here already in this declaration of 1972, quite a clear link between human rights on the one hand, fundamental rights as it's called here, and the environment on the other hand. Then if we move on in international environmental law, for instance, to the 1992 Rio Declaration, we find quite a different statement. For instance, in the Rio Declaration, I'm not going to quote that to you now, but we find much less of such a link between human rights and the environment. More a focus really on the environment, on sustainability, for instance, one of the things that was kind of important in Rio, if you like. And in some ways, these 2 declarations, Stockholm 72 and Rio 1992, are also reflective of being different approaches to the topic. Theories, if you like, to the issues of human rights and the environment. On the one hand, we have anthropocentrism, which kind of states that humans are in the center of everything. We protect the environment because that is good for humans, if you like. And on the other hand, you have ecocentrism, which kind of states that, or emphasizes that there's an explicit value also in the environment, in nature itself, independent of whether that's good for humans or not. Of course, there's a lot of theories that lie in between, but these being the both poles, if you like. So if we now look into concrete human rights treaties, universal human rights treaties, then we don't find such a right to a clean and healthy environment. If you look into the ICCPR, the International Covenant on Civil and Political Rights, you won't find it explicitly. If you look into the Covenant on Economic, Social, and Cultural Rights, you won't find it explicitly. And that's just a fact. We have to note that. However, I stress in this that, I mean, we don't find it explicitly. Of course, we find other human rights which create links to the right to a healthy environment. Think about the right to life. Think about the right to health. Think about the right to an adequate standard of living, and so on. Now, we don't have explicit recognitions in those universal human rights treaties. What we do, of course, have additionally is also regional human rights treaties. And there it's partially different. If you think about the African Charter on Human and People Rights, Article 24, if you think about Article 11 of the San Salvador Protocol in the Inter-American context, there we also do find some explicit recognitions of the human right to a healthy environment. And maybe some of you, those of you who have studied international law, are familiar in that context with the very famous advisory opinion by the Inter-American Court of Human Rights on the issue, on the interplay of human rights and the environment. So in the regional context, we do kind of see some explicit recognitions, if you like. But it's more flashlights, it's a bit erratic. It's not universal, legally binding declaration in a treaty. No binding source of that. So that's kind of the old part. Why is it an old hat? What's new now? Well, that brings us to October last year. And in October last year, we have Resolution 4813 by the United Nations Human Rights Council, in which, and I quote, the Council recognizes the right to a clean, healthy, and sustainable environment as a human right that is important for the enjoyment of human rights. Great success, celebrated by many human rights lawyers. Quite a big majority, 43 yes votes, with 4 abstentions, but these are significant states in international relations: Japan, Russia, China, and India. And China and India, I think we have 2 experts here today who can say something about that better than I can, but very interesting example. In particular, I think Peter will talk about this. India, which recognizes domestically a right to a healthy environment, but did not in October last year support that at the Human Rights Council. And in that UN Human Rights Council resolution, also the General Assembly was asked to take up the matter, and that now brings me to my last point, to July of this year, where the General Assembly did exactly that in Resolution 76-300, where the General Assembly recognized a right to a clean, healthy, and sustainable environment as a human right. Interesting enough, maybe again the voting, 161 votes in favor with 8 abstentions: Belarus, Cambodia, China, Ethiopia, Iran, Kyrgyzstan, Russia, and Syria. India, interestingly enough, had dropped, not their concerns. If you look into the discussions, they hadn't dropped their concerns, but they had dropped their resistance on the matter. So that now brings us to our panelists of today. I think we have managed to gather a diverse group of people today, I hope. Why diverse? Because I think we have some people being very euphoric about the new recognitions. I hope we also have some people who are quite critical about it. Yeah, we have not only European and Northern American ideas here, which I think we do far too much in these kind of events. We have also people here who can explicitly speak about other perspectives, for instance, the Chinese one, the Indian one, which I think is very important. Our first speaker is David Boyd. Let me very briefly introduce him. He's a professor of law, policy, and sustainability at the University of British Columbia in Vancouver. And it's very early morning for him, so I thank him very much that he made the time for us. He is a member of the World Commission on Environmental Law and of the Environmental Law Alliance Worldwide. And most importantly, David was appointed as the United Special Rapporteur on Human Rights and the Environment on August 2018 by the UN Human Rights Council. And I dare say in that capacity, it's fair to say he's one of the fathers of the resolutions of the Human Rights Council and the General Assembly. And in that way, it's not a surprise that he's quite an enthusiast about the topic. Let me finish with a quote that I found of his on the day of the General Assembly resolution, where he said, "The resolution has the potential to be a turning point for humanity, improving the life and enjoyment of human rights of billions of individuals, as well as the health of our extraordinary planet." So David, we are very interested here in how far that can be the case.
Thanks very much for that introduction, Pierre. Thanks for hosting this event. I think the question of whether the right to a clean, healthy, and sustainable environment is old hat actually goes back much further than Stockholm in 1972. I work with many indigenous communities around the world, and the concept of environmental rights and responsibilities as kind of reciprocal actions is deeply embedded in many indigenous cultures around the world and has been for thousands of years. But from a Western perspective, you're right, it really was the late 1960s when academics started talking about the right to a healthy environment, when civil society organizations started mobilizing for it. And you sketched out the evolution of the right quite nicely at the international level, but I think it's also worth mentioning that at the national level, Yugoslavia in 1974 was the first nation state to include the right to a healthy environment in its constitution. Portugal in 1976, Spain in 1976, Peru in 1979. And when we get to today, we can look at the fact that over 155 UN member states recognize the right to a healthy environment, either in their constitutions or in environmental legislation, or as parties to some of the regional treaties that you mentioned. So that's 156 countries that recognize this right in law prior to the United Nations recognition. So we actually have decades of experience with the right that have identified what it actually means and what kinds of impacts it can have. And so I think it's part of the enthusiasm for the recognition of the right to a healthy environment at the global level is the experience that has been the subject of some states where it's been recognized in their legal systems for some time. So in terms of the content of the right to a healthy environment, over time, it has evolved to include clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments where people can live, work, learn, and play, healthy ecosystems and biodiversity, and a safe, livable climate. And those substantive elements of the right to a healthy environment are accompanied by what I call a toolbox or a toolkit of procedural rights, including access to environmental information, public participation in decision-making, and access to justice. And then, like all human rights, there are a number of guiding principles which are really important. And interestingly, in the context of the right to a clean, healthy, and sustainable environment, these guiding interpretive principles are drawn from both international human rights law and international environmental law. And these include equality, non-discrimination, non-retrogression, prevention, and precaution, among others. So that's the way that the right has evolved in terms of its content over the last 50 years. And when we look at its impact, I think it's important to note that a major determinant of the impact of the right to a healthy environment in any national context, and to a broader extent in the regional context, fundamentally hinges on the rule of law. And if you're a country like the Democratic Republic of Congo, for example, where there are high levels of corruption, weak government institutions, very few resources for the implementation and enforcement of laws, then the right to a healthy environment has not made a substantial difference, as the same could be said for pretty much any human right in the Democratic Republic of Congo and other states where the rule of law is very weak. But in countries where the rule of law is relatively strong, we can see over the past 40 years that the right to a healthy environment has made a significant difference. It's made a difference in terms of the implementation and enforcement of environmental laws. It's made a difference in terms of public participation in environmental policy making. And most importantly, we have a small but growing body of academic evidence indicating that constitutional recognition of the right to a healthy environment is directly connected with improved environmental outcomes, faster reductions in air pollution, faster reductions in greenhouse gas emissions, higher proportions of the population with access to safe drinking water. And for me, that's the most important part of this discussion is, does this right actually make a difference for people on the ground where they live? And so now I want to come back to the impact of UN resolutions, because this is not a legally binding resolution. Neither the Human Rights Council nor the General Assembly resolution is legally binding. But I want to say two things about that. One is that I had a fascinating conversation with a judge from Brazil several years ago. And he asked me, he said to me, David, what do you think is the most frequently cited source of international environmental law in the Brazilian court system? And I didn't know the answer. He told me that it was the two were the Stockholm Declaration and the Rio Declaration, neither of which is binding in terms of being international law. So that was a revelation for me. And the other point I think is worth making is the last time there was a resolution of this nature was in 2010, when the United Nations, both the Human Rights Council and the GA, passed resolutions recognizing the human rights to water and sanitation. And so we have 12 years where we can look back and say, did that make any difference? The first thing we can say is a bunch of countries have added those rights to their constitutions in Costa Rica, Fiji, Mexico, Slovenia, Tunisia, and others. Many other nation states have changed their legislation on the basis of rights to water and sanitation. And most importantly, again, I'll reiterate, on the ground progress. So not only did Mexico add this right to their constitution, they put in place a program to deliver safe drinking water to rural communities. And they have succeeded in bringing safe drinking water in the last 12 years to over 1,000 rural communities in Mexico, a life-changing improvement. In Canada, where I live, Canada actually, for many, many years, opposed recognition of the right to water. But when the United Nations approved it in 2010, our government changed its position, recognized the right, and has spent the last decade working in tandem with indigenous governments to bring safe drinking water and safe wastewater treatment systems to more than 140 remote indigenous communities in Canada. So again, tangible impacts flowing from the UN recognition. I think that the other impacts these resolutions are going to have are yet to be seen in many ways. The right to a healthy environment is included in the draft text of the proposed internationally binding treaty on human rights and environmental due diligence. The right to a healthy environment is also in the draft text of the post-2020 global biodiversity framework. So at the global level, having these potential consequences. There's momentum for an additional protocol to the European Convention on Human Rights, which would incorporate the right to a healthy environment. There's new proposals in Africa and Asia for environmental democracy treaties on a regional basis, similar to the Aarhus Convention and the Escazú Agreement. So I think it's a really exciting and dynamic time. And my optimism stems not only from just believing very deeply that everyone on this planet has the right to live in a clean, healthy, and sustainable environment, but also I think from some lessons we can draw from history. So I'll leave it there, and I look forward to this conversation. Thank you very much.
Well, thank you very much. I mean, I would like to ask immediately two questions, but because you quoted the right to water so much, which is obviously one of my research fields, but I will not do that in order to, but I will ask you later. Anyway, we'll hand over now the floor to our second speaker, which is Marie Petersmann. She is a senior researcher at Tilburg, do I say this right? Tilburg, I don't know, Tilburg, let's say English, law school. She earned her PhD at the European University Institute in Florence and her master in Geneva at the Graduate Institute. And her monograph, sorry, I have to read the title because it's not yet appeared, will appear very soon with Cambridge University Press, When Environmental Protection and Human Rights Collide, the Politics of Conflict Management by Regional Courts. Marie also recently won a Veni grant for her new project, Anthropocene Legalities. And why I invited her maybe is because in some of her previous writings, she kind of expressed criticisms, I would say, about the merging of environmental agendas and human rights agendas, kind of saying this is maybe a wolf in sheep's clothing. So is it, Marie? We are very curious to hear what you have to say to us.
Thank you very much, Pierre. Let me just share my screen. Can you all see that? Wonderful. Yes. So it's nice that, David, you ended up on the note of optimism, since it's part of the title of my intervention today, the cruel optimism of a human right to a healthy environment. And cruel optimism is a term that I borrow from Lauren Berlant, who coined it to describe, and I quote, something you desire that might actually be an obstacle to your flourishing. And as Pierre just mentioned, my contribution to the discussion and my conclusion that the recognition of a human right to a healthy environment might entail a form of cruel optimism draws on my PhD research, which is forthcoming as a book. So this book, titled, as Pierre just said, When Environmental Protection and Human Rights Collide, Politics of Conflict Management by Regional Courts, explores how environmental protection laws and human rights emerged as autonomous bodies of law with independent rationale, normative goals, and political agendas, which over time started being linked both normatively and institutionally. In one sense, the book tells the story of this ever closer normative intertwinement and contextualizes how this happened, which actors were involved, which agendas were pursued, and which worldviews underpin those agendas at particular historical junctures, from the post-colonial to the human rights era, and later the sustainable development age. In another sense, however, the book tells the story of the consequences of this ever closer normative interconnection. Who did this agenda benefit? Whose interests and concerns were left out, and why? Without going into the details, the book argues that over time, a synergistic account of the relationship between environmental protection and human rights emerged with an overall disregard for the conflicts of norms that also underpin this relation. And as such, the book's main contribution is to retrieve, analyze, and contextualize the trade-offs between environmental protections and human rights norms. And throughout my research, I followed the decades-long debates about the recognition of the human right to a healthy environment from close, yet always with some skepticism. And although I consider myself as writing from within the critical legal studies tradition, my skepticism is not, or at least not only, alimented by the hype within CLS to point to the dark side, the hegemonic and alienating tropes of rights. I fully reckon that the pursuit of rights has empowered many marginalized and vulnerable peoples and enables them to tap into networks of solidarity across intersectional struggles, as Patricia Williams has showed. My skepticism rather is fueled by observations that human rights-based approaches to environmental protection have received the lion's share of attention, of policy momentum, and now of adjudicative traction to better protect limited and particular victims of environmental protection. And this is where, to me, the crux of the issue lies. Even in those successful cases that form part of the rights turn in climate litigation, the victims of the rights at stake are necessarily humans that are seeking redress and protection. If the right to a healthy environment will primarily further the living conditions of those directly suffering from environmental pollution, there will of course also be indirect results through cascading effects for the protection of the quote-unquote environment. Yet how can we foresee a livable present and future or a healthier life as such if we keep reducing the protection of the environment to human concerns? In my current project titled Anthropocene Legalities, Reconfiguring Legal Relations Within More Than Human Worlds, I take on this question to reimagine different ways to make sense of legal relations between humans and non-humans in more than human worlds. And I emphasize here the plurality of worlds to insist that no singular world exists, thereby countering the Eurocentric and colonialist enterprise that started with the great discoveries and was fused by the Enlightened period to globally impose a homogenized model of living through colonialist conquest of lands and of peoples. But I also emphasize the more than human, to actively decenter the category of the liberal, autonomous, rational, and free human subject to start instead from a dehumanist approach to living, where so-called human interests are intricately bound and interdependent from those of non-humans. Building on the problematization of the ever-closer normative intertwinement between environmental protection and human rights, of which the human right to a healthy environment is the epitome, I want to understand how relations between humans and non-humans could be legally reconfigured if, instead of invoking rights narratives, which inevitably splits rights claimants into atomized individual subjects, we would start from the premise that humans are entangled with non-humans. But what does it mean for humans to be entangled with non-humans? In my project, I engaged with entanglement in a twofold way. On the one hand, I draw on post-humanist, new materialist, queer and Black feminist theories to show how the category of the human is conceptually entangled with its negated figure, the non-human. Liberal understandings of the free, self-possessed and autonomous human being conceptually emerged through capitalist slavery, when with the Atlantic slave trade and the plantation logics that unfolded therefrom, the category of the human subject became exclusively reserved to the white colonial figure, relegating slaves to inhuman objects. And as the work of W.E.B. Du Bois and later Frantz Fanon, Sylvia Wynter, Tiger Hartman, and others have taught us, the very notion of being, qua modernity of ontology as such, has been reserved to a white subjectivity throughout Western modernity, where Black, Brown, and Indigenous peoples came into existence only through the eyes and as a negation of the liberal white human subject. My current project is therefore interested in this conceptual entanglement between the human and the non or the inhuman as categories of thought in order to reimagine ways to unworld, to undo or to de-world human-centric modes of inhabiting a world based on extractive, appropriative, and individualistic modes of being human. But my interest in entanglement goes further and also delves into entangled agencies between humans and non-humans on the other hand. And by entangled agencies, I mean that the Enlightenment-based understanding of humans' autonomy and freedom is actually a delusion, since the ability to act of any life form depends on its milieu and the myriad flows of energies and matter that animates one's actions in relation to others. And against this backdrop, I wonder, can the recognition of a human right to a healthy environment attend to the entangled agency between humans and non-humans within more than human worlds? Which world and which subjects is this right trying to salvage and secure? At what cost and for whom? Can such a right de-world the toxic present rooted in capitalist slavery to re-world a futurity that is not premised on the cruel optimism of liberal human subjects? How can we attend to the different worldviews, relational approaches, and unworlding practices that struggle to be accounted for in a human right to a healthy environment? How can we reimagine practices of care for more than human worlds without reinscribing a separation between humans and non-humans, but care for a relation that is existential to the maintenance of life on a damaged earth, or in the words of post-colonial scholar Achille Mbembe, essential to ensure the habitability of the planet. While I won't venture into concrete proposals here, I want to conclude by clarifying why, while I share the activism of those who have worked so hard over the past decade to have this right recognized, I do not feel, despite the solidarity, as cheerful as many of my colleagues today. And this has to do with another research project I conducted on the making and the unmaking of the Global Pact for the Environment. The recognition of a human right to a healthy environment was supposed to be the pinnacle of this instrument, to be recognized in its first article as part of a global and legally binding interstate agreement. Much energy, much time, many meetings, and a lot of money were devoted to the making of this Global Pact since its launch in 2015, following the adoption of the Paris Agreement, until its rejections by states in May 2019. In many ways, the recognition of a right to a healthy environment can be seen as a direct result of the actions of the Global Pact Coalition. This is, in and of itself, a success, even if both resolutions recognizing the right to a healthy environment are today deprived of a legally binding character. But is this self-recognition worth all the time, the work, the money, and momentum of this policy arena? Which world are we fighting for through such institutions and legal frameworks? Will this enable, not to come back to Berlin, be a cruel obstacle to the flourishing of a collective futurity that moves beyond the toxic present? And with this question, let me leave it here and thank you for your attention.
Thank you, Marie. I think I didn't promise too much when I called you a skeptic on the matter. I think we'll come back to some of your points later in the discussion, but I'll first give the floor to Otto now. And then at the end of all 4 presentations, we can have questions, and I'm sure there's quite a few on your presentation as well. Marie, so our third speaker is Otto Spijkers, who is a professor of international law at Wuhan University in China, where he's also a founding member of the International Water Law Academy. And he also currently serves as the managing editor of the Chinese Journal of Environmental Law. He's also one of the co-conveners of the Interest Group on Human Rights within the European Society. Otto, we agreed that you would talk a bit about the Chinese perspective, but also about your own perspective. So we are curious to hear your presentation.
Okay, thanks very much. I'm not using PowerPoint, so you'll just have to look at me or some other direction. So I have about 10 minutes. I will say something about the position of China, as was announced by Pierre, but I will also share some of my own personal reflections. But let me begin with China. So as Pierre already told you in his introduction, in October of 2021, the Human Rights Council adopted a resolution recognizing the human right to a clean, healthy and sustainable environment. And this resolution was adopted with 4 abstentions, including China. And the Chinese delegation issued an explanatory statement at the time, in which it was noted that China always attached great importance to environmental protection, and that it had written the concept of ecological civilization and the construction of ecological civilization into its constitution. So that's the Constitution of the People's Republic of China. So that is all very good. But at the same time, China believed that some of the contents of this resolution still needed to be discussed, including the very definition of the right and its relationship with other human rights. And also China questioned whether the Human Rights Council had the mandate to establish a new environmental human right. So that was the reason China abstained in the Council. And then on 28 July of this year, the UN General Assembly adopted a resolution, as Pierre already told you. It did so with no less than 161 states in favor and none opposed, and there were only 8 abstentions, again including China. By the way, some states did not take part in the voting. That explains why there's only 161 states voting in favor. For example, Venezuela did not manage to pay its fees, so it was not allowed to take part in the vote, and there are other such cases. So the representative of China at that time said that her country's National Human Rights Action Plan included a section on environmental rights, which is, of course, a fact. And she further told the Assembly that China recognizes the aspirations of the co-sponsors to promote discussions on environmental matters. However, in her view, or in China's view, there was no agreement on the right to the environment, specifically on its definition and its relationship to other human rights. So she, on behalf of her country, then requested for more time, patience, and efforts to avoid undue haste, expressing concern that a reference to common but differentiated responsibilities was not included in the text. And actually, that is a reason for many states from the non-Western world to be a little bit concerned. So for such reasons, China abstained. It did not vote against, but it abstained. So to conclude on China, I think it is fair to say that China does support environmental rights. It does so in various ways. And in fact, that such rights are easier to accept for a country like China than other types of human rights, especially the more civil and political human rights and rights that seek to protect individual freedoms. So environmental rights are not the most controversial human rights. But in view of China, more time is needed. This resolution just came too early. So let me now add some of my own personal reflections. I wanted to focus on 3 issues: on anthropocentrism, that is something that Pierre already referred to, on sustainability, and on human dignity. So first, about the anthropocentric nature of this right. So we humans, of course, have an interest in protecting our environment because of the goods and services it provides. And as long as the environment is in good enough shape to do so, some might consider it suitable or adequate or safe. But on the other hand, other qualifications like clean and healthy and non-polluted, they allow for a less anthropocentric approach. After all, even if there were no people at all in this world, the environment could still be considered clean, healthy, and non-polluted. But human rights, at least in my view, they exist for us, human beings. So by definition, we are the beneficiaries of human rights. So to accuse a human right of being anthropocentric, that is nonsense to me. I mean, by definition, human rights are anthropocentric. So would it not be better then to talk about a right that belongs to nature itself, for those that accuse international law of being anthropocentric? Or must we regard a healthy environment rather as a common concern or global public good of humankind, rather than exclusively that a right pertaining to individuals? But if we consider it a global public good, then I don't think it should be a human right. We should rephrase our claim in a different way. My second concerns or reflections are about the adjective sustainable. I wonder, how can a currently living individual, like me or you, be entitled to a sustainable environment? And what does that even mean? So instead of recognizing a human right to a sustainable environment pertaining to currently living individuals, that would be the present generation, I think it would make more sense to recognize a similar right to a healthy environment pertaining to future generations, and then we balance our human right to a healthy environment against that of future generations. And then my third and final reflection has to do with the link with human dignity. And this is something that I'm particularly concerned about. So a lot of these new rights, like the human right to a healthy environment, they seem to have lost this relationship with human dignity. Of course, without a healthy environment, you cannot live a life at all, let alone live a life in dignity. I mean, you will just die. But and the same rationale can be applied to human right to water, food, housing, oxygen or clean air, the right to sunshine, and so on. You need all these things to stay alive, so you also need all these things to live a life of dignity. But that's a different connection to human dignity than the more immediate connection between human dignity and the more classical international human rights, such as the right not to be subjected to torture, right to freedom of expression, right to choose your own religion or to be a non-believer, the right to choose the way your life ends, the right to privacy, the right to bodily autonomy and integrity, the right to choose the person you fall in love and wish to share your life with, and so on. So any breach of the latter type of human rights immediately constitutes a direct and often deliberate attack upon the dignity and freedom of the individual. But that link seems to be missing when we talk about human right to a clean and healthy environment. So I have some time left, so I want to end on a positive note. I don't want to ruin the mood or anything. So the Human Rights Council and the UN General Assembly resolutions recognizing the right to a clean, healthy and sustainable environment, they do give rise to cautious optimism. The recognition enables a further wave of human rights-based climate litigation around the world, like the world-renowned Urgenda and Shell cases in my country, the Netherlands. And the resolutions may give advocates, conservationists, campaigners, activists, anyone else who cares about the environment, a powerful hook to hang their work on. They can use these resolutions to hold governments and businesses like the global Shell Corporation accountable for endangering the health of our planet. And in addition, this international recognition of a human right to a clean, healthy and sustainable environment can also stimulate the drafting of legislation at the regional, national and local level. So there are many ways to make this historic recognition of the human right to a healthy environment matter. And I also agree with what David Boyd said earlier, that a lot of environmental law is based on soft law documents like the Rio Declaration and so on. We often refer to this as the Trojan horse. So these norms, they sneakily enter into the framework of international law as soft law. But then when they are inside, they can cause a lot of, well, not damage, but they can influence what's going on inside the city. Maybe I'm overdoing a bit this metaphor of the Trojan horse. I think my 10 minutes are now up, so I thank you for your kind attention and I look forward to any questions that you may have.
Thank you, Otto, for these reflections, for summarizing the Chinese position, but also giving your own ideas as well. And I would now turn to our last speaker before we open the floor to questions. To all of you, I know we have still a high turnout in the crowd, so I hope there will be also many questions. So our last speaker, last but not least, is Peter Kodiveri, who is an adjunct professor of clinical law and a research scholar at the New York University. She has previously worked on climate litigation inter alia. She has also supported rural communities in India to secure their land and water rights. and worked with Natural Justice, which is a collective of environmental lawyers. So Otto has already talked a bit about the importance of litigation for this as well. So I asked Peter to not only focus on the Indian perspective, which is particularly interesting in this case, I think, but also to bring in a bit of her own litigation experience, which she brings to the table. So Peter, you have the floor.
Thank you so much, Pierre. What I'm going to do is structure sort of my talk in 3 parts. First, I'm going to speak to the uniqueness of the Indian experience. The second part, I want to talk about the lived reality of the right to a healthy environment among the communities that I've worked with, and conclude with sort of takeaways both of cautious optimism as well as the future that this might hold, at least for climate litigation in India. So the Indian experience with international environmental law is a bit of a tough one to characterize very simplistically. If you look at Indira Gandhi's speech in Stockholm back in 1972, that's kind of the fulcrum around which a lot of India's interventions in international environmental law rests, because she spoke about the rights to a healthy environment, or any sort of environmental right, having to address the question of poverty. So India's political economy, as much as we're seen as one of the largest carbon emitters, we're also a highly unequal society. And that in a way realistically frames our ability to contribute to the progressive development of rights. And India's position on the right to a healthy environment, which I must confess I haven't followed closely, but what I can glean from the writings is the issue of equity. The fact that this particular right exists in domestic jurisprudence is a given. But I think when it comes to international law and the framing there, India often tries to guard its sovereignty and tries to create a space where it can continue to hold interpretive power over these rights. And that's sort of something you can even see in its positioning in international climate negotiations. So in some ways, you could say that the idea of safeguarding sovereignty as well as ensuring that poverty is not compromised at the altar of environmental rights kind of is one way to articulate the Indian position. But what's more interesting is the communities that I've worked with across the forested stretches in India have often mobilized around different kinds of human rights. And the right to a healthy environment has been part of a spectrum of human rights that they have used. And sort of drawing from Usha Natarajan's work and Naidu's work, one of the contributions that environmental justice struggles on the ground have made is actually push the envelope of international environmental law through the use of these legal frameworks, but have vernacularized it to the Indian context. To give you a very specific example, the Indian case where Subhash Kumar versus State of Bihar, where the right to a healthy environment was recognized, it was in a particular context of an environmental problem of water pollution. So the right to a healthy environment has been clarified to mean the right to a pollution-free environment. So there are a lot of nuggets and interpretations that the Indian environmental jurisprudence already has, which is fairly strong, and can potentially contribute to the development of the right to a healthy environment in the future internationally. But having said that, the other challenge that lies in the Indian context is competing varieties of environmentalism. And you must be wondering, why am I even talking about this when we talk about the right to a healthy environment? So if you look at Amita Bagaskar's work and Anuj Bhavania's work, they talk about how the public interest litigation system has been used by the upper class and upper caste to further certain kinds of environmental rights. And they've sort of categorized this variety of jurisprudence as bourgeois environmentalism. So now with the right to a healthy environment being recognized internationally and being mobilized domestically, the fear that I have is whose right to a healthy environment are we recognizing and whose right to a healthy environment is being compromised. Not to even bring up the question of caste in the Indian context, because the intersection of caste and environmentalism is a fairly violent one. So how does the right to a healthy environment act as an avenue for Dalit or lower caste communities to be able to assert their rights over the environment? So that is sort of a contested terrain on which this right rests. But at the same time, I think what I want to do is spend another couple of minutes talking about specific examples of cases that I worked on and where the right to a healthy environment is not seen as a, an isolated right operating without, a nested approach. So I want to speak to the case of the Niyamgiri mine, which was basically a bauxite mine that was going to be operational on a sacred ground of the Dongriya Khon community. Now, if you look at the particular outcome of that case, and I did fieldwork with these communities, they wouldn't necessarily articulate their legal claim as one of right to a healthy environment. They would instead say that they would like to conserve a stretch of forest. And within that, if you start to distill, you'll notice that it's a spectrum of rights intertwined and entangled. So the right to a healthy environment is rather couched in the everyday experiences of, we want to be able to protect this particular sacred land because it ensures that we get water, access to clean water through the year. Similarly, they want to steward these lands because it protects them from disease and gives them access to clean air. So in some ways, strategically, the legal claim is one of land rights, or it's one of stewardship, and the right to a healthy environment kind of is situated underneath that. That either is both a strategic choice, but also what is culturally relevant within these communities. But I want to conclude with a note of cautious optimism. And I think, as Otto also spoke about, the increasing wave of climate litigation. So what does the recognition of the right to a healthy environment do? I think we find ourselves in a time where the climate crisis is upon us and we're engulfed by it. And the law is now in a situation where it has to respond to this crisis. So I think it just opens up another legal hook and a pathway. And that opening up, I think, is an important moment for us to see what we can do in order to push the law to respond to the climate crisis or to increase climate action. In terms of what does it mean for the communities on the ground, and that's where I'm cautious, at least in the Indian context, it's who is mobilizing this right and how are they mobilizing it? So who has access to the courts and how are they infusing their petitions with a certain understanding of the right to a healthy environment? And my other fear also remains the strain of exclusionary conservation that permeates a lot of India's environmental law. That does a right to a healthy environment mean that we go back to fortress conservation? So it doesn't necessarily mean that, but in the Indian context, the rights of nature or any right always is exposed to that risk of interpretation. So how do we guard the right from being misused and in the hands of a certain bourgeois environmentalism that Indian jurisprudence has come to be defined by of late? So I'll stop with that.
Thank you, Arpita. And we have already many questions being typed, which I will read out in turn. I think if I ask our technical guru, it is also possible that someone asks a question and we include them and they can use their camera or their microphone, right? It's not only that we can read out questions. Is that correct, JP?
Sure, that should be possible.
So, if you like to show your face or your voice, that's also possible. Maybe that is a tiny bit more personal even. I will misuse my position as moderator to start with the first question because David kind of challenged me to that by making so many references to the right to water, if you allow. And one thing, David, that struck me is that one of the justifications you gave was to say, well, we can see from the right to water what a success this has been in 2010 with a very similar constellation with the recognitions in the Human Rights Council and the General Assembly. And my question is simply, how do we know that these successes that you attach to the recognitions by the UN are actually caused through the recognitions? You know, I mean, why do we know it was the recognitions in the General Assembly and the Human Rights Council that did this? You know, I mean, we also had the Sustainable Development Goals, which include water. It could also be a success of that. We had the annual reports by the IPCC, which state, you know, we need to protect our water better. You know, it could be other reasons that have created the successes in the case of water. We're not sure that this was actually the recognition in the General Assembly or the Human Rights Council. So how can we be sure that this is the case for water, and then how can we be sure that, or how can we hope that this will be the case for the right to a healthy environment? You have to unmute yourself.
Sorry, that's such a classic question, Pierre. The question of, is this just a correlation or is there some causal influence here? The two case studies that I know the most closely are the Mexican and the Canadian case studies, which I've looked at in great detail and spoken with some of the actors. And in those cases, people have said directly to me that it has been the recognition of the right by the General Assembly that was the catalyst for in the Mexican case, the constitutional change, and in the Canadian case for a policy change. In my work, working on the constitutional right to a healthy environment, I looked at this very closely, and I looked at the influence of the constitutional recognition of the right to a healthy environment subsequently on legislation and on court decisions. And in those cases, there's a very clear fingerprint, because in the legislative debate, you'll have references to the Constitution as a reason for amending or enacting new environmental laws. Similarly, in the case of jurisprudence, you have courts referring directly to the constitutional right, which means that there's that causal connection in those cases. I haven't studied the entire spectrum of cases of changes that have been made since 2010 in the case of the right to water, so it's a live question in many circumstances. But I'll leave it at that because of the shortage of time.
Okay, I will maybe read the first question that was asked in the chat room, which is by Lydia Young. For the skeptics, I would think in this case it's maybe Marie and Otto, but I don't know, maybe more or less. Is there any concern about spending too much time trying to find the perfect solution for environmental protection at the expense of the quite rapid action needed to tackle climate change and environmental catastrophes? The IPCC has indicated we have a short time to avoid some severe tipping points. Would any of you, Otto or Marie, maybe care to answer? Or someone else, if you want to.
I'm happy to just say a couple of words. I think that's really the crux of the question and a source of great concerns that I share. And I think that's what I was going a bit after with the research I did on the Global Pact for the Environment, to retrieve all the meetings that have been going and unfolding all over these years, while actually political action, as the IPCC is calling for, and Lydia Young is speaking about a perfect solution. I think this is definitely not one that would be found in these kinds of institutional arrangements. But of course, the momentum that is triggered by the rhetoric of rights is one that might mobilize, let's say, for political action. And I think the work that colleagues, the fantastic work that, for example, Julia Dem and Catherine McKelly have done on the conflicting temporalities between rights narratives on the one hand and political action, or mobilizing for political action and movements around collective social relations to rethink these modes of organizing beyond rights narratives, is really something that is very fundamental today. And especially this is also a literature that is very important in relation to Anthropocene critical studies and let's say the conflicting temporalities between deep time concerns and the very narrow and future at hand, basically, temporality that is invoked by rights narratives. And I think this connects also to another question that was posed on the chat on the effects of nuclear waste, for example. But this, we can go to that at a later stage in the discussion.
Would someone like to add something? Otto, maybe?
Yeah. So I actually don't think that combating climate change or mitigating its adverse consequences is a human rights issue. That is kind of the point I wanted to make earlier. So I don't think human rights is going to save the planet. This is not a human rights issue. So the solution is not in human rights law. It lies elsewhere. So maybe recognizing a human right to a clean, healthy environment may have some positive effects, but it's not going to save the world. Human rights are about something different. They're about guaranteeing individual liberties and freedoms, protecting the dignity of the individual against big corporations or big government. That's what human rights are about. They're not about protecting the planet. I mean, that's just my view. I'm not saying everybody agrees on this. This is just my opinion.
I'll certainly jump in there and say that I don't agree with that. I mean, the right to a safe, livable climate has been identified as one of the substantive elements of the right to a clean, healthy, and sustainable environment. We have recent decisions from the Supreme Court of Brazil, a court in the Czech Republic, a state court in Hawaii, all saying that the right to a healthy environment must include a safe, livable climate, because you don't have a healthy environment unless you have a safe, livable climate. That's basic logic. And the challenge that we face with the UN Framework Convention on Climate Change and its the Paris Agreement is that there are no enforcement or accountability mechanisms whatsoever in those international environmental agreements. But when you bring in human rights into the picture and you synthesize international environmental law and international human rights law, you get the normative content of the environmental agreements with the accountability mechanisms of human rights. And as you mentioned, Otto, one of the pioneering climate cases in the world is the Urgenda decision from the Netherlands, where a government was held accountable through the mechanism of human rights for taking action on climate. And that case obviously has been replicated around the world. So I think that I fundamentally disagree with the premise that human rights don't have a role to play in addressing the climate crisis. Are they a magic wand or a silver bullet? No, of course not. There's a tremendous amount of work that needs to be done. But can they be used to hold governments and businesses accountable? Can they be used as a catalyst for more urgent and ambitious action? Can they put a human face on this kind of global challenge? Yes, yes, and yes.
But I think we are both fighting a straw man, because I'm not saying that human rights are completely irrelevant. That's not what I said. I just don't think it all depends on this recognition of the human right to a healthy environment. And maybe I'm also making a caricature of your position, and for that I then apologize. I did not mean to do so. So I don't think human rights are irrelevant. That's not what I wanted to say. So I'm sorry if that was not clear.
Okay.
Maybe we can come back to one of the questions that was raised, which I think is quite good here, because it asks about what is actually the legal relevance, if any. And I think David has already spoken to this a bit, but this is a bit more specific about customary law. So the question by Ms. Wiffringhaus is, with due regard to its development and application in many regional and national treaties, and now even in the recent UN General Assembly resolution, would you say that it already attained the status of customary international law, at least regional customary international law? So obviously, David said already, General Assembly resolutions and Human Rights Council resolutions don't have the status of treaty law, not legally binding, but of course they can also express opinio juris, which is, one of the two parts of customary law. So maybe beyond some political meaning, there might also be legal meaning in those new recognitions. What is the position of our panel? David, would you care to answer to this, or someone else? Maybe Apita, or I don't know, or Otto? David, would you like, you're still unmuted. You're still not unmuted, so.
Oh, sorry, I'll let others go ahead and then I'll respond.
Okay, thank you. Otto.
Okay. Yes, so I think this resolution will definitely become a basis for litigation in my country. I mean, the Ruggie principles have been used in that way, and that's not a hard law. And they've been used very successful in the Shell case. So I'm sure when this case reaches the appeal and Supreme Court level, the applicants, that's Friends of the Earth Netherlands, they will invoke the resolution and it will be successful. I'm sure of that. But at the same time, it's kind of interesting to look at the explanation of the vote of some of the states that voted in favor. The US is an interesting example. So the US voted in favor, but if you read their explanation of the vote, they're basically saying, we don't believe there is a human right to a healthy environment, and we don't believe there will be a human right to a healthy environment, and we don't think that this resolution will create a right to a healthy environment. So then you wonder, then why did you vote in favor of the resolution? And so these explanations of the vote are, I think, interesting to read. But I definitely think it will have a huge impact on climate litigation in the future, especially in my country, where it's very easy to apply a soft law, to invoke soft law.
I didn't know whether Apita wanted to say something, otherwise David, I don't know. Did you want to say something, Apita? Okay.
I just wanted to add to what Otto mentioned. I think it's definitely going to provide a certain kind of platform and impetus for newer climate cases that are being brought out. I think in the Indian context, what it might do is actually revitalize an existing jurisprudence around this right, and I think bring it back to the fore. So that's both exciting, and we'll have to see how communities use it to safeguard their rights.
And I would just add that there has been an ongoing debate, as all of you probably know, for decades about some people advocating that the right to a healthy environment is already part of customary international law. And so these resolutions strengthen that side of the argument. You have 156 countries that recognize this right in their domestic legal systems or as parties to regional human rights treaties. And then if you look at the remainder of countries, the majority of them are actually of countries that don't yet legally recognize this right. The majority of those roughly 38 countries are small island developing states, many of whom signed the Malé Declaration in 2007, which includes the right to a healthy environment. So a political indication of support for the right. So there is an overwhelming number of countries that support this right. And whether that meets the bar for customary international law or not is an interesting question. I agree completely with Otto that some of the contradictory statements, the US, if you look at their public statements by the Biden administration and compare them with their end of explanation of vote, it's hard to reconcile. The other thing I would say is that, in terms of the impact of these resolutions, there's already been courts in Costa Rica and Ecuador that have cited resolution 48/13 from the Human Rights Council, not relying on it as the decision, as the crux of their decision, but as an influence on their interpretation of, in both of those cases, the constitutional right to a healthy environment. And there's no question, I mean, the way that legal systems are interconnected today, this right will be cited in courtrooms all across the world in short order. The Inter-American Court, which Marie referred to earlier, has been at the vanguard of this with their advisory opinion in 2017. I'm currently just finalizing an amicus brief in the first contentious proceeding in which the Inter-American Court will address the substantive content of the right to a healthy environment in an air pollution case involving a very marginalized population in a community called La Oroya in Peru. And so, yeah, it's exciting. And I think that Latin America is also worthy of mention because there's been so much conversation today about anthropocentric versus ecocentric. The Inter-American Court's interpretation of the human right to a healthy environment in the San Salvador Protocol is very much an ecocentric interpretation of that. In their advisory opinion, they said that what's unique about the right to a healthy environment is it protects both human health and well-being, but also protects the forests, the oceans, the rivers, the seas, on their own, not because they have benefits for humanity. And that pioneering statement in paragraph 62 of the Inter-American Court's advisory opinion has been picked up on by the Supreme Court of Colombia, the Supreme Court of Mexico. As Supreme Court of Mexico, I could recommend the Veracruz Reef decision from February of this year is probably the most comprehensive normative explanation of the basis of the right to a healthy environment that I've come across in my work. And so these Latin American courts are taking that ecocentric interpretation of a human right, which is really fascinating. And for me, I should also just say that the year before I became the Special Rapporteur on Human Rights in the Environment, I published a book called The Rights of Nature. So something that's near and dear to my heart as well. And reconciling those two potentially contradictory but potentially compatible concepts is something I'm very interested in.
Great. We had, I think Marie mentioned it already, a question about nuclear waste as well. So we have the question, how is all this progress and soon to happen agenda in developing human right to the environment play into the current dilemma of how to solve Fukushima nuclear waste introduced into the ocean? This is a question from a citizen from a neighboring country to Japan, deeply concerned. Marie, did you want to continue to speak on that? No, you didn't?
I wish I could, but I'm afraid I can only share the concern here again. And I guess indeed, how could, this would also be perhaps my question to the panel, how could a human right to a healthy environment help us mobilize action against concerns that are so deeply intricate that know no boundaries in terms of individuation when it comes to harms that are inflicted on human but also non-human, and really flows of water, of currents, of all the life forms that live within oceans, and on the soils that have been polluted by substances and radioactivity. How can we combine these different tools or worldviews, or I mean, I'm afraid I cannot help. I just share the concern and would advocate once again to think differently about the relations, the living conditions that on which life forms depend, and which I think a human right to a healthy environment might not be able to speak to.
Well, Marie, I agree with your concern, but I think that you have to look at what's actually happening, and it's not going to, again, this is not there is no single solution to all of the complicated and diverse challenges that we face. But, you know, just last week, or maybe it was 2 weeks ago now, there was a decision from a court in South Africa in a case brought by a group of, you know, what we would consider very marginalized rural people whose livelihoods are based on artisanal fishing. And their concern was with a proposal, in fact, a license granted to Shell to do seismic testing off the coast of South Africa, which they were absolutely terrified that this was going to not only damage their livelihoods, but also their spiritual relationship with the ocean. And I think that it's really revealing that in the court's decision, the court really did a lovely job of weaving together the concepts of sustainable development, the right to a healthy environment, and these cultural notions of interconnectedness with nature. Something that you see in some of these Latin American decisions I've been referring to, but also this was a very compelling judgment of South Africa. And, you know, for these, I've seen video footage of the celebrations of these fisher folk when the court decision was announced. The court decision struck down Shell's license and said it was incompatible with the right to a healthy environment, incompatible with the customary relationship of these fisher folk with the ocean. And so to me, that's an example. It's a really compelling example of how this can work. That's not to say it's always going to work. And I think that, you know, the question posed about Fukushima is an incredibly complicated one, scientifically, culturally, legally, but it can work. And I'm involved in court cases around the world where it is working for people. And for me, that's a really critically important piece of the puzzle, is it's making a difference in people's lives. Are there other approaches that could make a difference? Absolutely, yes. But this is making a difference and Arpita, I think your point in the Indian context is really important. You know, I'm not really interested in supporting wealthy people who are trying to protect a park in their community, but you know, the cases I'm involved in, like La Oroya in Peru, like Mpumalanga in South Africa, one of the worst cases of air pollution in South Africa. Again, a local community of very poor and marginalized people who have secured legal assistance to enforce their right to a healthy environment and succeeded through the South African court system. So I just think let's be careful and let's have rigorous academic debates, but let's also not lose sight of the people that we're trying to in power in these cases.
You mentioned litigation, and there's a question on interstate litigation, if you like. So maybe I can read this from Marina Trindade, building on the previous question. In case of codification of customary law through the contribution of the UN General Assembly resolution, would this see interstate litigation in the foreseeable future in the context of weak climate action adopted by different countries, and also in the context of climate interventions adopted by countries and their global effects? Would someone care to answer this? I think we talked a lot about domestic litigation now, and now the question is about interstate litigation. Would someone?
Well, I mean, isn't human rights law, isn't that about the relationship between the state and its nationals or those residing within its jurisdiction? So human rights law regulates that relationship. Of course, there have been cases before the ICJ that are based on human rights law, like the cases about the death penalty in the US and so on. But primarily, so then a state exercises diplomatic protection on behalf of a threatened individual. But yeah, I think for interstate litigation, maybe human rights is not the obvious choice of legal framework.
David, you have also unmuted yourself.
Yeah, I was just going to say that there was a case brought by 16 children and youth to the UN Committee on the Rights of the Child, in which those young people tried to assert their human rights in an extraterritorial way. And the decision of the committee was they had not exhausted their domestic remedies, so the case was dismissed on those grounds. But the committee did open the door to those kinds of extraterritorial cases. And there's also a case which is proceeding in the German legal system of a Peruvian farmer who has sued a German utility company for its contributions to the climate crisis. There's also been cases of people from Nigeria successfully suing Shell in the Dutch court system for violation of their rights. So I think that this is definitely at the frontier of litigation, but it's a promising and fascinating frontier.
Yeah, but none of those examples are interstate litigation. That was kind of my point. They are all between individuals and a state.
Individuals, I guess I misunderstood, Otto, because I was just saying they're individual. It seemed like you were saying individuals versus their own state, but I was just trying to clarify that individuals can, in this new frontier, bring cases against other states. State to state versus state, I think, is also something we may see in the future. Small island developing states have certainly raised the possibility. Some of the statements by politicians in Pakistan in light of the devastating heat wave and floods, I could imagine Pakistan bringing a case against another state. It's obviously going to be highly contentious and very difficult, but in light of the circumstances, we need to, I mean, states like Pakistan really need to try every possibility.
We have a question also on climate refugees. May I ask what impact these developments on the right to a healthy environment might have on those often referred to as climate refugees? Can we expect any changes in this context? Will climate refugees be the ones left out of any enjoyment of the right to a healthy environment? Goes a bit in the direction, I guess, of the previous answer. Anyone wants to answer this question?
So maybe I would just like to refer in response to this question to a fantastic short blog post that was posted yesterday by Dylan Asafo, titled "Climate Justice Demands a World Beyond International Law." And Dylan Asafo is part of a symposium edited by Dina Tsuvala and Niloufer Oral on climate change in an unequal world. And Dylan Asafo takes the example of a climate refugee, an asylum seeker who based its procedure on the basis of being a climate refugee, I think from Tuvalu, whose claim was rejected, and how this plays out. Of course, this is an example where it's going to be we will be facing increasing considerations of climate refugees, not only by humans, but there are also a lot of academic debates about climate refugees beyond the human, let's say, in reference to non-human mobilities and e-mobilities triggered by or blocked by international law when it comes to drastic climatic changes. So, well, just referring to this piece that was posted yesterday, I'm happy to post a link in the chat.
Okay.
It's a tough question. I would just say that this question of climate migration and human rights is one of the top priorities of the new Special Rapporteur on Human Rights and Climate Change, who was appointed by the Human Rights Council last October, Ian Fry from Australia. So something to keep an eye on.
Okay, we have a quite broad question on the definition of the environment. Sorry, I have to navigate. We have so many questions. Where was this now? There. How do we even define the term environment? Is it the present or also the future environment? Is it the planetary ecosystems in the current evolutionary state that is constantly changing? Is it the relationship between humans and the environment, e.g. humans being protected from natural disasters and able to use the environment for their own needs? Is it understood as what is not human? May it be that the different understandings of the term or focusing on different aspects of the concept is at the heart of the debate on different protection mechanisms, human right versus right of the environment, common heritage, and so on? Would you say that's the problem? Yeah, Otto.
Yeah, I think that is a really excellent question and also a very important one. Because so if you look at earlier case law on the human right to a healthy environment, and that's mostly the case law that of the European Court of Human Rights that I'm familiar with, it's always about very specific pollution or other kind of harm done to the environment, like a polluting factory. So people living near a polluting factory and they are seriously affected by this pollution. So then the threat to the environment is very specific and very easy to identify. But if you look at the new wave of climate litigation, for example, the Urgenda case and the Shell case in my country, that is not about a specific form of pollution. Actually, it's about pollution that has not even happened yet. It's about policies, environmental policies, not being ambitious enough. So it's about the future. And these are very different cases from the old style healthy environment related cases. And then what exactly the environment may be that is at risk of being harmed. Yeah, in any case, it's seen in a more general sense, and it's almost not defined. So the potential harm is not defined in clear terms, and also not the beneficiary of this protection is not defined in clear terms. And that makes them very different from the older cases relating to a healthy environment, which were always about harm already being sustained, and they were always about very specific harm. But new climate litigation is about future harm, so harm that has not yet taken place, and it's about a lack of ambition in future climate policies.
David, do you want to add something on this? I mean, which role did the existence or non-existence of a definition on the environment play a role in these two resolutions?
Well, this is a question, and this is actually, I think Otto mentioned this as one of the reasons that China wasn't willing to vote in favor of these resolutions was a lack of definition. But this, from my perspective, is a bit of a red herring. I mean, let's look back at 1948 Universal Declaration of Human Rights. Were any of those rights defined? Were there definitions of any of the terms? No. So that to me is an argument that's made by people who are either deliberately trying to mislead people about the nature of the recognition of human rights. I mean, every country in the world has environmental legislation that defines what the environment is. You know, I just pulled up Canada's definition of the environment here. They're generally quite well encompassing. Environment means the components of the earth and includes A, air, land, and water, B, all layers of the atmosphere, C, all organic and inorganic matter and living organisms, and D, the interacting natural systems that include components referred to in paragraphs A to C. That's a pretty broad and encompassing definition of the environment. I agree with what Otto said, that there's still particularly in the European court system, the European Court on Human Rights has taken a very narrow view of the environment, has said explicitly in several cases that the existing rights under the European Convention do not include a right to nature itself. And I think that's one of the compelling arguments we can make for why an additional protocol to the European Convention on Human Rights is needed that recognizes the right to a healthy environment, because it brings in these broader concepts that the court has not yet incorporated into its jurisprudence.
Sorry, can I ask a quick follow-up question? I'm just curious, David, do you think we are part of the environment, human beings?
Yes, absolutely. We are living organisms. We share DNA with every other form of life on the planet. So absolutely, we're part of the environment. And I think, that's something I write about extensively in my book on the rights of nature, the kind of philosophical conceptualization of humans as being separate from and superior to nature is one of the most damaging ideas of Western society in terms of the crisis in which we find ourselves. And it's much more compelling scientifically and normatively to recognize that humans are animals and we are part of the environment ourselves.
Peter?
I just wanted to add to what has already been so explicitly made, but that legally defining the environment is also in some way, and it's a site of contestation. It's about multiple actors operating in certain political economies trying to interpret what it means. And that while that sounds like a bit of an abstract point, I think I want to give the example of the Adani solar park that's being contested in Rajasthan. And it's a fascinating case because the solar park is seen as India transitioning in a greener direction when it comes to energy. But they located it on farmland, which was livelihood concerns for the local farming population there. And at the same time, it was also home to the great Indian bustard, which is a bird that's almost extinct. And the headlines actually read quite hilariously where it says, big blind bird stops India from transitioning in a greener direction when it comes to energy. So in terms of the stakes about how does one legally conceptualize the environment, is it a source for redistributive justice? Is it a source for species protection? Is it relational in terms of humans and non-humans? And I think it's an iterative process. I think statutes freeze the definition, but the life of what the environment means in jurisprudence is constantly shifting. But hopefully in a direction where, at least in the Indian context, it's moving more towards an ecosystemic approach, which is exciting.
Yeah, I would actually add to that, Arpita, that there are some really exciting examples of where the definition of the environment is actually extending beyond the kind of scientific definition that I articulate from the Canadian Environmental Protection Act. New laws in New Zealand, for example, to do with the Te Urewera ecosystem or the Whanganui River, they define those places in a way using legal pluralism and the views of the Maori people in a way that's really compelling. And I would say I don't say this about much legislation, but actually beautiful and poetic. And there was a court case in Canada recently about an area which was a sacred site to an Indigenous people, and whether building a ski resort in that sacred site would actually violate their freedom of religion. And I think that we're seeing these kind of, it's challenging Western legal systems to incorporate these indigenous laws into in Canada. When I went to law school, I was taught Canada has two founding legal systems: the civil law from France and the common law from the UK. And now, 150 years after the country was founded, we're finally realizing, oh, wait a minute, there's a third legal system that predates those, called Indigenous law. And how do we incorporate Indigenous law into the contemporary fabric of Canadian society? It's a massive challenge, but it's also really a fascinating legal frontier.
We have a few more minutes, so maybe I can, so many questions, but there's one here from Pakistan, which picks up on a point that has been discussed before. Maybe I make this a bit shorter. At the multilateral level, Pakistan has voted for the UNGA resolution this year, as well as a UN Human Rights Council resolution last year, but has emphasized that issues concerning the environment must also take note of the common but differentiated responsibility. My question is, why isn't there more action and engagement on this common but differentiated responsibility? I think Otto mentioned this before in his initial statement, if I'm not mistaken. Would someone care to comment on that? Because I think this is something that you read from quite a few states, this concern. Otto, do you want to follow up on this, or David, do you want to say something on that?
I just want to repeat indeed that this was one of the main reasons why China abstained. And even some, or actually quite a lot of developing states that voted in favor, they expressed these kind of concerns. So this is a really big thing for many states.
Yeah, it was a very contentious aspect of the negotiation of both the resolutions at the Council and at the General Assembly. And the compromise that was reached at the General Assembly was to refer to principles of international environmental law, which was seen as an implicit articulation of common but differentiated responsibilities, which really wasn't satisfactory to anybody. But, you know, in the context of the global climate crisis and the failure of northern states to address the issue of loss and damage, I think that this is absolutely a critical issue going forward. It's going to be a huge point of contention at COP27 in Sharm el-Sheikh in the fall. And we really need, I mean, I believe very strongly that we need to make progress on loss and damage, as well as financing for mitigation and adaptation, as well as technology transfer. I mean, the global north is just really shirking its responsibility as the primary creator of the problem.
Yeah, Apita.
No, just to quickly tack on to David's point about loss and damage, I think framing loss and damage as a right to a healthy environment issue is an interesting way to articulate it. It's about who gets to enjoy the right to a healthy environment at the cost of what, and what is the sort of colonial, history of extraction that frames the enjoyment of this right. So, climate reparations is an important angle.
I want to bring in another question. I try to choose diverse questions so we don't discuss on the same issues all the time or on two specific issues. If it's about specific countries, it's often hard for us to answer, I would say. But this question I think is very interesting. Do you see any problems concerning democratic legitimization when courts are the ones forming and defining a right to a healthy environment? Realistically, it feels like governments are avoiding to find a consensus and instead let courts decide a matter that should be discussed with all the concerned and all the marginalized groups. So, I mean, in this case, it's not, yeah, I don't know. I mean, it was decided by it was now kind of in the resolution by the General Assembly and the Human Rights Council, which is of course not a court, but it is of course true that filling this right with content will probably left to the courts. This is the way I understand this question. So, I mean, yeah, I could also answer this, but maybe one of you wants to answer it. Maybe as a starting point, I can say that's kind of often the case with all rights. You know, I mean, in the beginning, they don't really have a clear definition. And it's often the courts that will fill, will put flesh on the bone. And I think it will be the same here. But maybe others have different opinions on that.
Yeah, I think. Well, sorry, Otto, you go ahead. Go ahead, Otto.
Oh, okay. Yeah, because this is a big discussion in my country after the Urgenda and the Shell rulings. So some politicians, more on the populist side of government, they even called my country a dicastocracy. That is a country that is ruled by judges rather than by democratically elected politicians. So that is a big accusation to make, right? That it's no longer the government that decides how to run the country, but now it's judges that do. And they do so based on very vague and general provisions of international law. And in the Netherlands, it's actually the government that concludes treaties. So oftentimes when we become a party to a treaty, there's very little democratic control. That's the argument, that we are now becoming a dicastocracy rather than a democracy. I think it's ridiculous, but it is good to take these concerns seriously because quite a few people share them.
Any other? I think originally David wanted to say something, or I don't know.
Perhaps just to add that
Okay.
maybe it's also important not to see that too much in a binary way, in the sense that many of the climate litigation we are speaking about, be it the Uganda case, the German Nauer case in France, Notre Affaire de tous, I mean, I'm not speaking about the European examples here. They were very much fueled and intricately linked with social mobilizations of youth movements, so of course these invocations of rights in courts is one thing, but we should not lose the bigger picture of what's happening on the street. And this is also where I think perhaps the most important work is to be done, and where when we speak about invoking also, as Peter said, I mean, or was it Otto, a different futurity, a different world that is to be built, that is to come, that is very much one where the question of political economy that Peter raised is really, this is where the debate is actually happening more than in courts, where we see these judges invoking these rights very much already as part of a world that is being actually contested and trying to be dismantled. So I think, yeah, we should keep track of that broader debate.
Yeah, I would agree, and I would say that court decisions just get a disproportionate amount of popular attention, media attention, and unfortunately academic attention. The reality is, if we do apply a rights-based approach to these challenges, that means engaging with the people whose rights are at risk. And to give one beautiful example of how this has worked in a positive way, my first country mission as a UN Special Rapporteur was to Fiji, which is obviously a small island developing state on the front lines of the climate crisis. I visited a community that was one of the first in the world that had to be completely relocated because of rising sea levels and saltwater intrusion that was of their water supply and their agricultural lands. But in Fiji, the government has, to its credit, worked closely with over 50 different communities that are on a waiting list for relocation to develop some rights-based guidelines for community relocation. And it really was driven by these communities, really is focused on their rights, and really provides a blueprint for recognizing and implementing not only their right to a healthy environment, but all of the myriad human rights which are being affected by a community that has to pick up stakes and move to a different location. I think that's a compelling example of how a rights-based approach can actually be done in a legitimate way and has nothing to do with the courts.
I have one quick question, and then I would ask one last question from the crowd. I know, David has to go, I think.
I'm sorry, I'm already late for another meeting, so I am going to have to depart. But thank all of you for such a fascinating conversation.
Yeah, then we'll let you go, and maybe then we also skip maybe the other questions. I think we've had plenty of questions. Then let's close on time. And thank you, David, for being here. Thanks, Marie. Thanks, Peter. Thanks, Otto. I think it was a pleasure. I hope it worked out that we had very different accounts on the matter. It's always a bit the danger if you have a topic like the one we had today, that you have four people with four very similar opinions, and that was really the one thing we wanted to avoid. And so we tried to gather a group of people that had very different perspectives, some of them more optimistic, some of them more critical, from different regions of the world. And I think that has, in my opinion, at least, this has worked actually quite well. So thanks to everyone for being with us. I can see there's still quite a few people here. Some have left now, but I think we are well in time. Thanks very much for all your efforts, and I see you all very soon. Thank you. Bye-bye.